I want to give a definition of guardianship here. So I'm going to the slide now that says guardianship. If you can hear me, Sheila.
Can you hear me?
I can hear you fine. Yes.
Okay, good. Sorry about that.
I'm on the slide that says guardianship now. It's got the definition of it. All right. So guardianship. Really, a guardian, like it says here, is a person who is going to be given the legal power or duty by the court to take care or manage the property or the rights of a person who, due to really incapacity, that's a big word we're going to talk about later, is considered unable to manage their own affairs. And so courts in states, and I want to really be real specific about this, each state has their own distinctive law related to guardianship, but it's important that you understand that courts are directed by law to use what's called the least restrictive alternative in ensuring the needs of an incapacitated person are met. So next slide, please. So guardian has two things. It could be the guardian of the person or the guardian of the estate. Primarily with Angelman syndrome, it actually includes kind of both of these facets is the way I would understand it to be. And it's really the guardian of the person is the person who's responsible for decisions that are related to the health care, living arrangements, custody, maintenance, training, education, all kinds of services, vocational opportunity, pretty much the continuum of life. And really the guardian of the estate deals with the finances. So what we're talking about are two different distinct things, the person and the estate for guardianship. Okay, next slide, please. A big part of guardianship deals with the incapacitated person. The definition of incapacitated person is an adult, and we'll talk about an adult with Angelman syndrome here, whose ability to receive and evaluate information effectively and communicate these decisions is in any way impaired to such a significant extent that partially totally unable for them to manage their financial resources. And I put his, and I'm going to speak in the masculine sense throughout most of this presentation, but it's masculine or feminine. It can be he or she. About their financial resources to meet essential requirements for his physical health and or safety. Okay, the next slide. The next slide is about court determinations. And so it's important to understand that the nature of the conditions impairing capacity to make communication decisions are made as such. It's made to the extent of the individual's capacity to make and communicate decisions. It may be necessary at times to provide more authority to the individual and maybe not as much a need for guardianship. And I'll talk about some of those options as well later on in the presentation. But really, it's the need for guardianship services in light of availability of family, friends, and other supports to assist the individual in making decisions, and in light of the existence of a power of attorney or trust. And you can actually still have those things enacted, but again, guardianship is going to be the most restrictive form of being involved with an adult who may have not to have the capacity to make decisions. One of the big things in the judicial determination of capacity, particularly of older adults in guardianship proceedings, relates to the 6 pillars of capacity. And this shows what those are specifically. So it relates to their medical condition, their cognitive ability, their functional behavior, what their values and preferences may be, risk and levels of supervision needed, and means to enhance capacity. So these 6 pillars are really critically important when you're trying to determine the capacity of an adult or a child with Angelman syndrome. Sheila, next slide, please. Are you able to hear me pretty good?
I can hear you.
Great. So right now, Sheila, we're on the functional element, which is probably the most important part of the determination of whether you're going to have a child or well, we're talking about an adult child with Angelman syndrome. in guardianship. And really it boils down to how does the person function in life and society. And when I say that, I list some bullet points here. I want to know these type of questions, or the courts want to know these type of questions. What is the ability for that person to care for themselves? Make medical decisions, which are critically important. Really make residential decisions. That's a tough one, I think, for most families to consider. I think my wife and I, and I'm sorry I didn't really have a chance to formally really introduce myself, but let me say this. I'm a parent of an 8-year-old daughter who's deletion positive with Angelman syndrome. And we have done many of these things that we're talking about. We have developed, the special needs trust, and we know there will come a time where we're going to have to make decisions related to guardianship. And the primary reason is about the residential decision. And what will that look like? Is it going to be 24/7 staff residence? Is it going to be a group home? Will they continue to live with us until we are not able to provide the care for them? Those things are important to have spelled out, and I think they're really important as you think about the future as well. How well do they function in the home, at home, and in the community, and what is their ability to take civil and legal action? And I'm going to give you some court proceedings which are going to follow. So the next slide is a court proceeding out of Pennsylvania. And this court proceeding was from the Pennsylvania Supreme Court, which held that an intellectually disabled woman was not in the need of a guardian, despite what her need for dependence on others, because what she had developed was a circle of support from caregivers. And really that circle of support assisted her to meet her essential requirements for health and safety and really managing her financial resources. Therefore, she didn't need guardianship. And that's what the Supreme Court upheld. And this court was something that was the result of a protection and advocacy that got involved, where a young lady was in an institutionalized setting, and the guardian continued to make residential decisions without really taking in consideration what her needs were. So they actually said, she's not in need of a guardian right now. She just needs a circle of support to help her. And it wasn't, in fact, family members that were her circle of support. Was her guardian, but her circle of support were people who were advocates who were advocating for her to have the best life possible. And as a parent, I want that for my child. But the decision for guardianship is going to come whether I'm going to be the guardian to make sure that those resources are available, and then considering that in the future as well, what would that look like? So the court must also determine whether it's going to be plenary or limited guardianship. So is it going to be of the person or just the estate? The court is required to prefer limited guardianship. And this process can be expensive. It can take a lot of legal proceedings to make guardianship come to fruition. And again, I want to emphasize it's different state by state. What I'm giving you tonight is really just kind of the basics. And this presentation, this webinar will help you as you start making decisions about guardianship in the future. So except in specific areas, the guardian is given authority. The partially incapacitated, really when you're talking about limited, the partially incapacitated person retains all other legal rights. And then also the court has to determine what's going to be the duration of the guardianship. How long is it going to take effect? And that's a big thing to think about as well. And there are lots of legal forms that must be managed annually to kind of maintain the guardianship, maintain the ability to be the guardian as well. Okay, Sheila, we're moving forward to the next slide here, which is the legal procedure. So how does it work? So the way I've read and done the research to kind of understand it and talk to people is that first it's got to be a petition filed in court, depending upon state-by-state consideration. Some states say it may be at 18, some say it's 21, some say it's conservatory, or some call it guardianship. It just depends state by state. It may be filed by any party interested in the alleged incapacitated person's welfare. And you'll see the acronym here, AIP, that's the incapacitated person is what that acronym stands for. In the petition, it must contain a description of their functional limitation, along with their physical and mental condition of the incapacitated person, the reason why the guardianship is being sought, really some steps to take that have been taken to find really what's called the least restrictive alternative, and the name of the qualifications of the proposed guardianship proposed guardian. There's actually a place that I borrowed some of this information from. It's the Center for Guardianship Certification, and the Center for Guardianship Certification actually has a certification process, and their whole function as a nonprofit is to make sure that they help find certified guardians that follow very specific training and procedures to become guardians. And this is moving on to the next slide, Sheila, which is legal procedures. And the legal procedures continued. You must have a written notice that has to be served to the incapacitated person according to the state-defined due process prior to the hearing date. And it must be also explained to the maximum extent possible in the language and terms of the individual so that it's able to be understood. So if that's with an AAC device, or if that's with text system, or just communication with sign language, however it may be, they have to try to provide to the maximum extent what it means to be be considered to have a guardian. And the services also are required of relatives on relatives who would be heirs. In the situation with Angelman syndrome, that's not likely to happen, and I would actually advise that when looking at this last bullet point here, just thinking about assets and Medicaid, which is another area that I talk about a lot, you really don't want to have, if you want to maintain Medicaid benefits, you don't want to have any money in the adult with Angelman syndrome's financial institutions, banks, or any other type of financial accounts, because what Medicaid's going to do is they're going to liquidate those assets just to be able to ensure that they're being recouping some of those assets if they have it. So parents, make sure you don't keep money in those accounts of your children and your adult children, at least in my opinion. They're also given the right to counsel. This is a big aspect of it. So the child with Angelman syndrome, or what would be considered an incapacitated person, has the right to be represented at the hearing. And I'm talking a lot of legal jargon here too. So I'm going to say from now on, where it says AIP, I'm going to use an Angelman syndrome adult. If not, the Angelman syndrome adult may request the appointment of counsel, and the court has to appoint counsel if it's deemed to be appropriate. Now, a lot of times when it's parents that are applying for guardianship, the courts aren't going to deem it to be appropriate. They understand what the process is. It's parents trying to ensure that they have the guardianship rights to help make the decisions of their adult child. And the appointed counsel can, in fact, they'll be paid often by the county or the state of the Angelman syndrome individual if they cannot afford it. And again, this is another aspect of why there may not need to be any finances in their accounts, because then really the burden becomes on the county and state to provide the counsel without really the parent having the burden of that as well. Now that may not always be the case state by state, but in some states that I've did some research on, that is in fact the case. The petitioner must notify the court prior to the hearing if counsel has not been retained for the child with Angelman syndrome, and the adult child with Angelman syndrome has the right to request an independent evaluation as well to determine their capacity to make decisions. All right, so then we move to what would be the hearing portion of the guardianship. So I'm on the hearing slide now, and as you're thinking about any type of court proceeding, you've got to have a hearing. And in this situation, the child with Angelman syndrome must be present at the hearing. And so if that's the case, they would have to be there unless really a physician or a licensed psychologist says that it would be in harm for them to be there. And that's typically unlikely to be the case. Or that incapacitated person or their child is absent from that commonwealth or that state. And really, the burden is on the petitioner to prove the incapacity. and the petitioner must present testimony from individuals qualified to evaluate the type of incapacity alleged. And so I'm kind of a stickler about keeping documentation, particularly from the school situation. In my role as a school counselor, I try to keep all of those reports for families very distinctly in those IEP folders so that families have access to them. And I mean, that's by law. We should be doing that. But as a parent, I also want to make sure I keep track of all of that documentation because I know I'm going to need it later. I've got an 8-year-old right now, but later I'm going to have to be able to present that information to a court if I decide to seek a guardianship for my daughter. So I'm moving now from the hearing to what would be the effect of guardianship. So what does a guardian do? And so we've gone through the process to determine that the child with Angelman syndrome does need a guardian to help them make the decisions related to their residential situation, their finances, their medical decisions, to continue to manage seizure control. You've got the guardian in place. In effect, the guardian is very much like the parent, is how I look at it. But really what the guardian is doing is they're educated totally to the incapacitated person and making sure their rights are being followed. They're entering into a contract. They make gifts. They accept, reject medical treatment. They decide where the Angelman syndrome child is going to live, and they manage their financial affairs. And some of these things do have financial implications because once you become a guardian, some states allow residential situations where you can actually receive compensation from the child with Angelman syndrome if they're living, in fact, in your residence as a parent. Again, that varies state to state, but there are some financial implications. And to have that additional financial assistance does, I think, often help families it continue to improve their quality of life. Now I want to talk a little bit about power of attorney versus guardianship because often we become very familiar with power of attorney situations, particularly when it comes to older parents, where sometimes we as adults have to take power of attorney from our older parents who are not able to make the decisions related particularly to expenses. Power of attorney is appropriate and guardianship is not if the individual has capacity. Again, the burden of incapacity is on the petitioner. So as the parent, you've got to be able to determine whether it's going to be the necessity for a power of attorney or guardianship based upon the capacity of the individual. And with Angelman syndrome, that capacity can vary quite a bit, but the power of attorney does not involve the loss of rights or autonomy of the individual, but it does allow the individual to exercise control by planning in advance and avoids expense and burdensome of the court involvement because guardianship is an expensive process to get through if you're going through the court system. Not always the case, but it takes some money to find the right, to get all the way to the hearing section of the law. Guardianship is necessary if an individual lacks capacity. So it goes back again to the need of a decision maker. And as parents, we often understand we have to help make decisions for our Angelman children too. And I often hear the word which would be considered natural support, and if a parent is considered to be a natural support. Yes, we are natural support, but in a lot of cases, what we would be considered as a natural support often are making what I consider to be unnatural choices and decisions. We have to provide that support that typically would not be given to an adult child. We're providing that support for a child who doesn't have the capacity to make some very important decisions related to their life. And so many medical decisions are one of those things that can be made by relatives under the Act 169. And that simple finances can actually be handled by joint bank accounts and the Social Security Administration representation payee status. But still, sometimes there's definitely a need of guardianship when it comes to residential situations and other major life decisions. So what are the post-education duties of the guardian? The guardian has the duty to assert the rights and best interests of the incapacitated person or the child with Angelman syndrome. and each state law may be very specific, but definitely should include the following. We want to see the incapacitated person has outstanding health needs, and they need to be addressed. They need to evaluate all the living arrangements for appropriateness and safety. They want to make sure that there's an existence, and this is one of the things that's probably typically required in most of the things I've read. And it's kind of morbid to think about, but they want to make sure that they determine the existence of funeral and burial arrangement and make them if none do exist. So that's one of the duties of a guardian. Additional duties include gather information on assets, gather information on debts. In our case with children with endangerment syndrome, again, I want to advise families to limit what our children with endangerment syndrome would have in accounts and limit the obvious what they would have in debts. Because they are going to need to have all those things together for the child with endangerment syndrome to make sure that they because they are entitled to Medicaid. And they could potentially be entitled to Medicare. They could potentially be entitled to SSDI. And they all will be entitled to supplemental security income. And if you didn't have a chance to see my previous webinar on government benefits, I explained a lot of this in the previous webinar about government benefits in children and adult children with endangerment syndrome. And they should have a separate bank account for the incapacitated person. But in that bank account, that would, if you have Medicaid, limit the assets to at least below $2,000. And then the rest can be put in trust. It's okay to have the special needs trust. The trust ensures that you can buy other things that you may need for your child with adult child with endangerment syndrome. But keep that bank account below $2,000 if you actually are getting the benefit of Medicaid. And then set up some written record keeping system to track all assets, income, expenses, and other financial affairs. And really, this is a biggie. States do not allow commingling of the endangerment syndrome assets with any of the guardian's assets. We're going to definitely be talking about a lot more of this stuff at the biennial conference, which is going to be coming up soon. I want to put a plug in for that as we move to the duties of the guardian in the next slide. That conference in July this year is going to be free registration for all families. And so we want to encourage families to come to the Chicago area, attend that conference. There will be much more information about guardianship, government benefits, along with a multitude of other great sessions that we want to be able to share with families. So as someone who really wants to put a plug out there, I want to encourage people that are listening to attend that if possible. Moving along with the duties of the guardian, it's important that the appropriate state reports are filed annually. They need to be filed annually. They need to be made sure that they're completed, and that all reports are reviewed according to the state process that's in place. And I put this bullet down too because sometimes you hear about guardians. They have a living arrangement with their incapacitated person or the child with endangerment syndrome, and it's important that they do visit that child with endangerment syndrome. And state laws vary on how often. I would say at least the best practice would be monthly, because you got to take in consideration of making sure that their care is being provided adequately and appropriately. And if it's one of our loved ones, we want to make sure that they are visited on a regular basis. And then you got to make sure you do some care planning for within conferences, care planning conferences at any nursing facilities if they are necessary. If there's a change in health, if the guardian needs to be at all those meetings that involve any type of care planning. All right, I'm moving to the next slide. So I want to talk a little bit about if something were to happen and the child with endangerment syndrome would be able to be deemed to have the capacity after guardianship had been provided. That is a possibility. And so guardianship is going to be reviewed. It's not normally reviewed, but it can be reviewed And so it's something that can take place, and it can be revoked. Well, the guardianship cannot be revoked like the power of attorney, but there have been some cases that I've read where guardianship has been reviewed, and we went back. I'll go back to the slide about duration. Some states have a very distinctive period of time where guardianship has to be reviewed within a set period of time, every 5 years or something like that. But if capacity was to come in play, and there was for some reason capacity became more prevalent in the individual, then it'd be difficult to revoke, but it could be reviewed and then revoked after the state deemed it to be necessary. So here's some other things about legal options, and this is kind of just some review of some things we've already talked about. Again, when you get to the legal options, petition the court for review. The court shall conduct a review hearing promptly if incapacitated person or the guardian or any interested party petitions the court for a hearing for the reason of a significant change in capacity or a significant change in need for guardianship services. I read a couple case laws related to guardianship where, unfortunately, sometimes guardians don't make the best choices for their child that has a disability, intellectual disability, or incapacitated, and it was necessary for there to be a hearing to make a change because actually the services were not being provided appropriately. And sometimes, as an aging caregiver, us being, wanting the desire to maintain guardianship over our adult children, there may come a time when we, as an adult provider, guardian, we become incapacitated ourselves, and therefore our guardianship of our younger children will come into question as well. So if the guardian has failure to perform their duties according to the law, it's really in the best interest to change for the child with Angelman syndrome. But again, the burden is on the person advocating to continue the guardianship. So if I advocate to continue the guardianship, but there's a question about my ability to provide the guardianship for my child, obviously the court's going to be pretty strict and look at that and say, I'm sorry, Mr. Wright, you're at a point in your life where you're not able to provide, be the guardian of your adult child with Angelman syndrome. I pray that never comes to fruition for me, as I'm sure I'm speaking to many families that have children with Angelman syndrome, and many parents out there tonight. You're listening to this and you're thinking, "Oh, this seems like an arduous process. It seems so." It seems so menial to have to say that you're going to be a guardian for your child in some sense. It really is not. I don't look at it from that standpoint. I think it's necessary. But then there will come a time when I know it's going to be necessary for me not to be the guardian of my child as well. And then the court can request an independent evaluation on my ability if considering my guardianship in the future. I'm going to show the next slide, Sheila, which is going to be the United States of America with all the states, including Alaska and Hawaii. And this is from the Center for Guardianship Certification. And what I want to show is that all the states in Hawaii, they really have no certification or no specific training for certification to guardianships. But you can see that the states in the blue, including Florida and California, they do have a state certification which is required. And Nevada and Illinois, New Hampshire, and Alaska, they have they have to have the Center for Guardianship certification, which is required. Their headquarters are listed. I mentioned them earlier. They're headquartered in Pennsylvania. Ironically, Pennsylvania does not require any type of certification. I found that amusing when I was looking at the slide. And then Oregon requires the certification and a state certification. So if you are a resident in one of these states listening tonight, you do have, in Texas, Arizona, and Washington, you have a state-specific requirement. It's important to know what those requirements are, and you can turn to the Center for Guardianship Certification in Pennsylvania. So just a quick Google search if you were on the internet, and I think I may have mentioned it later in my presentation, that you could contact them. They're a nonprofit organization that would be able to assist you to understand what the requirements are in your state. Now I'm going to talk about, and I've talked about guardianship, and now I'm going to talk about some alternatives. and to guardianship. And so in doing this, I always feel like it's important to talk about alternatives to guardianship because there might be other things to consider. And I'm an advocate of some, but I'm also an advocate of guardianship as well. And it just depends on the situation. It depends on the child. It depends on how they will be as an adult. It depends on a lot of circumstances that are completely out of my control. But here are some alternatives. So based on the capacity of the individual, it might just be necessary for people to have advocates and advisors who can help them plan their life out. I also am a firm advocate of person-centered planning. And that process is something that is becoming more prevalent in today's society, where you take the individual themselves and you center a whole planning process around them of what their wants, desires, their needs are, what their likes and dislikes are, what they potentially could have a living arrangement be like, their employment situation. It's an arduous process. It's a long process, but it's one that is being advocated for, particularly by the Department of Medicaid, the Center for Medicaid Services, and also a lot of advocate groups such as ARC of the United States of America. Those organizations are advocating for person-centered planning. We talked briefly about power of attorney, and I discussed what the rights are what the power of attorney would hold rights over an individual who may have some limited capacity. The durable power of attorney is a little bit different. Again, as someone who's not an attorney, I didn't get a lot into that, but that is an option. Additionally, with the durable power of attorney for a healthcare designee or a patient advocate, those people would be able to have control mostly over the financial means of the individual and also help them make healthcare decisions. There could be some protective orders that would maybe come in play at times. That would typically be more related to if someone was not upholding the civil rights of an individual that had was incapacitated and was not taking care of them appropriately. Therefore, you can, if you see that ever, take protective orders against that individual and let the courts determine what would be the next steps. I'm a big fan of trust as well. I'm a fan of special needs trust, and I think that as we continue to plan for our children, our soon-to-be adults someday with disabilities, it's important to have those trusts enacted and written, and therefore could be managed accordingly. Some of it may be contract. It could be finance, like a representative payee, which is particularly relevant when it comes to the Social Security Administration. Those are some alternatives. And again, I'm going to go through each of these kind of briefly as well. A representative payee is a person or an organization designated through the Social Security Administration that actually handles the Social Security check. And again, going back to my previous webinar on government benefits, I talked about SSI and the Social Security Administration and how that will impact an adult child with Angelman syndrome at age 18 when you're, if for some reason they're not able to receive SSI now, but they do get SSI later, you can have someone who can handle that too. And they have special paperwork to appoint a representative payee, and it can be revoked if the Social Security Administration deems it necessary. Personal money manager is someone who can just kind of manage the individual to make sure they're paying their bills, handling their finances, investments. Just again, an alternative. Automatic bill pay is something that could be set up if the individual has their own residence, which could be placed in a trust, by the way, a residence within trust. Then the bills could be paid out of their trust and make sure that they're being paid automatically as well. And I also am a big advocate to do a little estate planning for people with disabilities because you want to preserve their eligibility for governmental benefits. I underline that. Let me emphasize that. That do provide essential services, which can include residential services. And so I am a big advocate to make sure that there is some estate planning. And it's a tough pill to swallow as a parent of a child with Angelman syndrome in some sense. Although we do it for our typical children, neurotypical children, I'll say. And when we do this, you have to think you're just trying to, provide something for your children in the future. but with a child with a disability, it's particularly important to make sure that those assets are preserved correctly so it doesn't have an impact on the governmental benefit. So talking about trusts, I want to talk about those. There's a couple different kinds of things the homeowner should be familiar with, which is a settlor grantor, who is the person who creates the trust. The trustee is someone who will manage the trust, and the beneficiary is the person who receives the beneficial use of the trust. And so there are some type of trusts for people with disabilities, particularly child with Angelman syndrome, one of which is a support trust. That's probably the most relevant. I think my wife and I actually have it set up as a support trust. But there's Medicaid qualifying trust too, which the most common that I hear about is pool trust, but these other two I'm not as familiar with. I'm most familiar with the pool trust because it's a Medicaid qualifying trust, and the support trust is what is typically written for most people that are looking to do estate planning for their child with Angelman syndrome. Let's briefly talk about fiduciary duty. A fiduciary is someone who has undertaken a relationship of trust and confidence to act on behalf of another person. They are held at the highest standard of care and law of equity, and the fiduciary must put the person's interest before his or her own personal interests. I hate to say this, but I read a number of articles when I was doing a little research on this, and I want to emphasize this too. The fiduciary duty of a trust is critically important. And there was a mention of a number of trusts that were being held with substantial resources with very little support funds coming out of those trusts provided the adult child or the adult with the disability. It wasn't specific to Angelman syndrome, but it was specific to individuals with intellectual and developmental disabilities, and the trusts were not being enacted correctly. And so now you will find that many banks have now put a fiduciary agent who is literally hired full-time to make sure they're handling special needs trusts. And it's important that you find those people, and when you're doing the process of setting up the trust and when the trust is going to be enacted, that you have the right fiduciary agent, the fiduciary person who can handle off the aspects of the trust. The support trust really is exactly what it says. It provides support, care, and maintenance of the beneficiary. It can be created and funded by anyone, including the beneficiary. It does not preserve eligibility for government benefits. Depends on how that's written. You can, at least my understanding is the support trust is really providing the support. But the pool trust with the support trust is the way I would typically do it. Take the support trust funds and put it in the pool trust, and therefore you're going to manage the benefits that are going to be out there, particularly Medicaid and SSI. And it's really typically established by family members for individuals with special needs who do not need government benefits particularly. In our case, I am planning that my daughter's going to need Medicaid, so our support trust is going to be in a pooled index trust is what it's called. The third-party amenities trust is established and funded with assets of a third party, which is a family member. It provides for amenities and extra items or services. It could be recreational activities. I've heard this, one thing that I heard recently was very interesting is I heard someone who set up a trust that included a vacation. And it's so a weekly vacation, an annually vacation that would be at least a week or 2 weeks. And some people would actually trusted, I think it was Disney Vacation Club. And so the individual with the developmental disability really was excited about that. And so every year they get at least 2 vacations to Disney. And I love it. That's exactly the kind of thing that I want for my daughter later in her life. If I'm not walking on this earth, I sure would like to have her go to places that she likes and have a vacation that she could have. But it also can take care of home furnishings, haircuts, music therapy, equine therapy or horse therapy, water therapy, and if properly written, it preserves the beneficiary's eligibility for government benefits. And the amenities trust does preserve that benefit. It enhances their quality of life, and it provides for trustee to act as an advocate. So I've gone through this, and I'm going to talk lastly about the pool trust. The pool trust is used to preserve the benefits of the government as well. And it's typically administered by a nonprofit organization. In Kentucky, we have the pool trust. Sub-accounts are established for the benefit of the individual, and all the remaining assets are left with the nonprofit organization. And in Kentucky, we have the beneficiary would be protection and advocacy. I'm not going to get into this as much, but there's payback self-settled trust and established by a family member, just briefly, with trust buyers. And so it could be that you have a younger family member, and as you become older, they will have the trust buyers, and they're typically awarded in a lawsuit. Funds with beneficiary funds awarded from a lawsuit would be I'm sorry, I was confused. That was confused. It's funded with the beneficiary's own fund, so it's not something that I would typically see very often with a child with Angelman syndrome. And so last, I just want to talk about what trust can be used for, and I'm a big advocate of trust. Medical treatment beyond Medicaid, dental care, vocational services. I talk about recreation, travel. It could be the difference between success or failure in placement in a home or residential. My goal, actually, I think, for our daughter is that we would like to have them have their own home, and then we would be able to support that through the residential component of Medicaid with the ability of having a trust enacted should we not be here to ensure that they have that ability or that trust is being enacted. But it can also be used by music, books, movies, those type of things, travel, as I mentioned before. So this is my presentation to the folks in the Angelman Syndrome Foundation community. And I will turn it back over to Sheila and open it up for some questions, and I sure hope I can answer.
All right, can you hear me, Eric?
Loud and clear.
Okay, good. All right, so we do have a couple questions. And I apologize for the technical difficulties that I was having in the beginning. Not sure what happened, but some of the questions, one of them we think that you kind of answered, but we just want to make sure. What would be an example of how we would prove incapacity?
Well, it goes back to really that paper trail. Incapacity is going to need to be documented by a psychologist or a psychiatrist. And it could be those school papers on your most recent integrated assessment report, which is required every 3 years under IDEA, which is the Individuals with Disability Education Act. That paperwork could be utilized in establishing whether the capacity is there. It could be also medical professionals that are currently working with your child, your physician. It could be a speech-language pathologist. It could be an occupational therapist. It could be a physical therapist. They would write up reports to support, if that's what your state requires, is written reports. Or if they're asked to come and testify, they would testify of what their functional ability would be. And that's something that can be used. With Medicaid, a lot of Medicaid states are using what's called it's developed by the American Association for Intellectual and Developmental Disabilities. It's called the SIDS document. And what the SIDS document is the supports intensity scale. And what the supports intensity scale is used for is it determines what type of supports and what type of intensity is necessary to make sure that individual is able to live as independently as possible. And if you have that Medicaid assessment document, that could be used as well. I hope I answered that, but I feel very comfortable with that answer.
Okay. Another quick question was people wanted to know if we can post your PowerPoint presentation on our website. So will that be okay if we post that?
Absolutely. A lot of this information was taken from about 17 different states, the Centers for Guardianship Certification, the ARC of Michigan, Tennessee. I mean, so yeah, this is taking a lot of information and putting it together to the best of my ability.
Okay. We do have a follow-up to the incapacity question. It says, I know that Social Security recognizes Angelman syndrome under compassionate list. Isn't this enough in proving incapacity?
That may vary change by state by state. Remember, it's going to go to the least alternative. It's kind of the least restrictive environment in education, but it's called the least alternative. Guardianship is really going to be the least alternative legal proceeding for an individual because they're really going to be relinquishing their rights. So each state may require very different type of situations. One state may require an actual testimony from a physician, and another state may just take the form from SSI, from Social Security, and they would be able to use that. Again, it's going to be important that they do get some, and the best place I want to recommend that people contact if they have specific questions about their state is either the Centers for Guardianship Certification in Pennsylvania, or their protection and advocacy organization within their individual state that deals directly with intellectual and developmental disability.
Okay. Another question is, how long does the guardianship process typically take to complete? So at what point of the child's 17th year should this process be initiated?
I would say you're going to start, I'm honestly talking about here in Kentucky starting during the tail end of the 16th year. So in Kentucky it could take up to maybe a year is what I've been advised. So, I mean, that may be a state-by-state situation, but I would recommend that you're looking at least maybe a year in advance, but again with the right type of legal advice from within your state. And I would have to know more about what state that was, and if they wanted to reach out to me directly to the Angelman Syndrome Resource Team, I'll be glad to help them find out more specifically in their state.
Okay. I think they're just a heads up, but I think they're from Minnesota, so if you want to look into that. And then one last question is, at what point should the application for SSI be initiated? They've heard that it can take some time to complete the process, and the child should be eligible to begin receiving promptly at 18 years old, yet it is not retroactively paid out.
That is actually not true. If they've been given that advice that it's not retroactively paid out, that is not the case. They once with the process is enacted, at least, you know, I've dealt with this case a number of times. It is retroactive, being back to the beginning of their 18th birthday. And so it's, again, that is a state-by-state, you know, situation. But in most situations, I would say it's about a 4-month process.
Okay.
And that's again, if they haven't had the opportunity to watch the webinar related to governmental benefits, they could look at that, which is a little bit more detailed about that. But then, again, if they wanted to contact me directly, tell them to feel free to reach out to me. Go on the Angelman Syndrome Foundation website under Family Resources and Family Resource Team, and make a request to have me work with them directly, and I will be glad to reach out to them.
Okay. All right, so it looks like that's kind of all the questions that we have for now. If you guys do have any other questions that you think of later that you want to send, you can go ahead and send those in to us, and we'll get them over to Dr. Wright to answer. I did want to thank everybody for attending tonight. This session has been recorded and will be put up on our YouTube channel as well as our GoToMeetings channel probably tomorrow or the next day. So if you want to listen to it again, you can. But thank you, Dr. Wright, again for having a webinar for us. And good night, everybody. Thank you.
Hey, Sheila?
Yes?
Can you stay on for a few minutes or not?
How about I call you on your cell phone?
That'd be great. Let me give you my cell number. You have my cell number?
Yep, I got it.
Okay, great. Just give me a buzz back, okay?
All right, thank you.
All right, bye-bye.
Bye. Good night, everybody.
Good night.